Response to district's denial of discrimination complaint. To Karen Duber, District Director of Employee Relations and Title IX Compliance. From Hassan Sadr. Dear Ms. Duber, thank you for your August 7, 2025 correspondence regarding my discrimination complaint. I respectfully disagree with the district's determination and wish to provide additional clarification and legal context. First, procedural objections, statute of limitations analysis. While you reference AR 3430's one-year limitation period, this administrative timeline does not supersede federal civil rights statutes of limitations, which typically range from 2-6 years depending on the claim. See Wilson v. Garcia, 471 U.S. 261, 1985. The continuing violation doctrine may also apply where discriminatory policies remain in effect. National Railroad Passenger Corp v. Morgan, 536 U.S. 101, 2002. Sufficiency of pleading standards. The district applies an inappropriately restrictive standard in evaluating my complaint. Under federal civil rights law, I need only provide enough facts to state a claim to relief that is plausible on its face. Bell Atlantic Corp v. Tumbly, 550 U.S. 544, 2007. Administrative complaints should be construed liberally in favor of the complainant. Substantive discrimination claims, age-based discrimination. The district's denial of financial aid based on my possession of a previous degree from 30-plus years ago constitutes age discrimination. This policy disproportionately impacts older students and lacks educational justification. Under the Age Discrimination Act of 1975, 42 U.S.C. Section 6101, federal fund recipients cannot discriminate based on age in educational programs. Supporting case law includes Kimmel v. Florida Board of Regents and Massachusetts Board of Retirement v. Murgia, national origin and immigration status discrimination. The evidence demonstrates coordination between IVC financial aid staff and USCIS that goes beyond normal administrative processes. Despite Department of Education approval and funding allocation, IVC consistently refused disbursement. 4 separate Cal Grant payments of $1,500 to $1,600 each were returned to the Department of Education without legitimate educational basis. This pattern suggests discrimination prohibited under Title VI of the Civil Rights Act of 1964, California Education Code Section 66270.6, and Plyler v. Doe. The district's own BP 3430 specifically prohibits discrimination based on immigration status and national origin. Requested remedies. I respectfully request the district conduct a full investigation of discriminatory practices in the Financial Aid Office, calculate and provide reimbursement for financial aid improperly denied, and review policies that create disparate impact on older and immigrant students. Implement training for financial aid staff on civil rights compliance and establish monitoring procedures to prevent future discrimination. Preservation of rights. This response does not waive my right to pursue remedies through the U.S. Department of Education Office for Civil Rights, federal court under 42 U.S.C. Section 1983, state court under California civil rights statutes, or other applicable administrative or judicial forms. Documentation request. To facilitate resolution, please provide all financial aid office policies regarding prior degree holders, communications between IVC staff and federal immigration authorities, records of all Cal Grant and FAFSA funds returned, and statistical data on financial aid approval rates by age and immigration status. Conclusion. The district's cursory denial fails to address the substantive evidence of discriminatory conduct. Rather than dismissing these serious allegations on procedural grounds, I urge the district to conduct a thorough investigation consistent with its stated commitment to equal opportunity. I look forward to your response within 30 days and remain hopeful for an amicable resolution that upholds the civil rights of all students. Respectfully submitted, Hassan Sadr. Enclosures, supporting documentation, relevant case citations, federal agency correspondence, copy to U.S. Department of Education Office for Civil Rights.